Good morning, this is your Kelso Report for Friday, May 4th. I'm your host, Clark Kelso. We have today a revenue and tax case from the Ninth Circuit, a venue in criminal cases, a decision of the California Supreme Court, and a new tort, intentional interference with expected inheritance, recognized by a California Court of Appeal. We'll begin with a tax case. In the state of Morgan's versus Commissioner, the Ninth Circuit confronted the tax question whether gift taxes paid by the donee trustees of a qualifying terminal interest in property trust based on a Section 25191 deemed inter vivos transfer of that Q-tip property within 3 years of the donor's death must be included in the transferor's gross estate under the so-called gross-up rule of Section 2035. Affirming the decision of the United States Tax Court, the Ninth Circuit held that the gift taxes paid by the donee must indeed be included in the transferor's gross estate, thereby requiring the estate to pay additional estate taxes. The basic theory here, which is supported by the statutes, is that although the gift taxes are technically paid by the donee, they are actually being paid for the benefit of the transferor under a net gift economic analysis. Next, California Supreme Court in People v. Thomas, where the court clarified the application of California statutes dealing with venue for criminal proceedings as applied to crimes that occur in more than one county. Now, in general, the proper venue in which to prosecute a criminal offense is the Superior Court of the county in which the crime was committed. That's Penal Code Section 777. Well, Penal Code Section 781 then provides that when a crime is committed in part in more than one county, or when the acts or effects constituting the crime or requisite to its commission occur in more than one county, the offense may be prosecuted in the Superior Court of any of those counties. In People v. Thomas, the defendant lived and sold drugs in Madera County. He possessed a key and a receipt for a storage locker that was located in neighboring Fresno County. The storage locker is where he kept the drugs and a firearm. The Court of Appeal had ruled that the drugs and firearm located in Fresno County did not provide a basis for prosecuting defendant in Madera County for possession for sale of a controlled substance and possession of a firearm by a convicted felon. The California Supreme Court disagreed, concluding that Section 781 was a remedial statute that should be interpreted liberally. The Supreme Court came to a very practical and common sense conclusion. Madera County was a proper venue, given the evidence that Madera was the defendant's base of operations and that he participated in gang activities there and sold drugs there. The defendant lived in Madera and was a member of a Madera County gang that had engaged in drug sales, and when he was searched, the defendant possessed a large amount of cash in addition to the key and receipt. There was, in other words, ample evidence that the defendant lived and sold his drugs in Madera with his inventory just across the county line, and venue was therefore appropriate either in Fresno or Madera County. Lastly, our new tort. In a matter of first impression, the 4th District held in Beckwith v. Dahl that California should recognize, as most other states have, the tort of intentional interference with expected inheritance. The elements for this new tort are as follows. Number 1, an expectation of receiving an inheritance. 2, intentional interference with that expectancy by a third party directed at the testator. Number 3, the interference was independently wrongful or tortious. Number 4, there was a reasonable certainty that, but for the interference, the plaintiff would have received the inheritance. And 5, damages. One additional limitation is that the plaintiff must show he or she does not have an adequate remedy under the law of probate. Factually, the plaintiff in Beckwith alleged that his longtime partner, who was facing surgery to repair damage to his lungs, was prepared to sign a will splitting his $1 million estate between his partner and his estranged sister. When informed by plaintiff about her brother's intention to sign such a will, the sister told the partner not to have him sign the will so she could quickly prepare a trust which he could sign to avoid probate taxes. The sister allegedly did not intend to present such a trust for signing in a timely manner before the surgery, because she knew that if he died intestate, she would inherit everything. In fact, the surgery did not resolve the problem, and he died 6 days later, never having recovered consciousness. The court held that, as pled, the plaintiff did not satisfy the elements of the tort, since the misrepresentation and fraud in this case, namely that the defendant was going to prepare trust documents, was directed at the plaintiff beneficiary, and the tort requires the independently wrongful or tortious conduct be directed at the testator, not the beneficiary. Because the lower court had dismissed the complaint on the ground that there was no such tort in California, the 4th District remanded to give the plaintiff the opportunity to amend his complaint if possible. This is obviously a very important case, since it recognizes the possibility that heirs who are denied relief under the probate laws may nevertheless have a tort claim for relief in circumstances where someone has tortiously interfered with the testator's decision-making about inheritance. And that's it for today's Kelso Report. Have a great day in the law.